Local officials demanding answers after federal agents and troops gathered at a park for what appeared to be an immigration-related operation, but the mayor claims the only thing interrupted.
There's a growing tension inside American law enforcement, and it's not coming from Washington. In counties across the United States, sheriffs are making headlines for refusing to comply with ICE detainer requests. That means when ICE asks them to hold someone longer than the law allows, without a warrant, some local officials are now saying no. It's a rare moment of defiance, and it's reshaping how immigration enforcement works on the ground. In places like Orleans Parish, Louisiana, and several counties in Iowa and Illinois, sheriffs are putting their legal necks on the line to avoid what they say are unconstitutional holds. At the same time, they're being pressured by governors and federal officials to cooperate or face the consequences. This conflict reveals more than just a disagreement over detention. It's a sign that the ground is shifting under ICE's feet and that local law enforcement might not be willing to play along anymore. In this video, we'll break down what's happening with ICE detainers right now, why local sheriffs are defying federal pressure, and what it could mean for the future of immigration enforcement, and for immigrant families who thought their court date was the end of their case, not the beginning of a new threat. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. To understand what's happening, let's start with the basics. ICE detainers are not warrants. They're requests sent by Immigration and Customs Enforcement to local jails, asking them to hold someone who would otherwise be released just a bit longer, so federal agents can take custody. This hold can extend a person's time in jail by up to 48 hours, often beyond the legal limit. It may not sound like much, but in the eyes of the law, it's enough to trigger serious due process concerns. Over the last few years, these detainers have come under fire from civil liberties groups and federal judges alike. And now some sheriffs, yes, sheriffs, are joining the resistance. In Orleans Parish, Louisiana, the Sheriff's Department made headlines by formally announcing it will no longer honor ICE detainer requests that lack a judicial warrant. That decision followed multiple lawsuits, one of which involved a man held for 4 extra days without a conviction, a judge's order, or any criminal record. Legal experts describe the case as a clear constitutional violation. And it's not just New Orleans. In rural Iowa, a sheriff went public in early July with his concerns about the legality of detainers. He emphasized that his deputies are not federal agents and should not be asked to detain individuals without proper court authority. According to him, complying with ICE could open the department to lawsuits, and that risk is too great to ignore. These sheriffs are not activists. They are career law enforcement officials, often elected in conservative districts. Their defiance isn't ideological, it's legal. They are warning that following ICE's requests without a proper warrant may violate the Fourth Amendment, which protects against unlawful search and seizure. But their warnings have not gone unanswered. In Iowa, Governor Kim Reynolds criticized the sheriff publicly, accusing him of undermining immigration enforcement and siding with undocumented individuals. In Louisiana, Republican lawmakers have proposed bills that would strip funding from sheriff's offices that refuse to cooperate with ICE. The National Sheriff's Association, caught in the middle, is now requesting formal clarification from the federal government, asking how far local agencies are legally expected to go. Behind all of this are the families and individuals affected. For an immigrant held on a minor charge, maybe a traffic offense, maybe something dropped in court, a detainer can turn a 24-hour jail visit into a life-altering experience. People are being rearrested, transferred into federal custody, and often deported without ever seeing a judge. Sometimes the original arrest didn't even result in charges. That's the danger. And for sheriffs, it's becoming a moral question as much as a legal one. ICE, for its part, has pushed harder under the Trump administration's second term. New executive orders encourage aggressive detention practices, and the newly passed Big Beautiful Bill includes billions in additional ICE funding. Field agents are under pressure to deliver results, and detainers are one of the fastest ways to do that. But what happens when the local jail says no? That's what's unfolding now. In some counties, jails are changing their policies. They're training staff to reject detainers unless accompanied by a signed court order. They're advising families of their rights, posting release dates publicly, and notifying legal aid groups. In turn, immigrant advocacy organizations are creating hotline systems to respond within hours if someone is illegally held. Some sheriffs, such as in Travis County, Texas, implemented similar policies years ago. But in 2025, it's different. These policy shifts are spreading, and they're happening in places previously aligned with federal enforcement. That shift reflects a deeper anxiety that ICE may be setting up local agencies to take the legal fall if something goes wrong. If someone sues over being held illegally, it's the sheriff's office, not ICE, that faces the lawsuit. And as settlements pile up, counties are starting to push back. The legal questions here are murky but gaining clarity. Multiple federal courts have ruled that ICE detainers alone do not justify continued detention. In 2020, a federal court in Illinois ruled that Cook County had acted lawfully when it refused to honor a detainer. That decision set precedent, and now in 2025, it's being cited by sheriffs trying to protect themselves from liability. What's likely next? We could see a deepening divide between jurisdictions. States like Texas and Florida are expected to pass laws requiring sheriff cooperation with ICE, while others may move to protect departments that say no. Lawsuits will continue, and eventually, the Supreme Court may be forced to step in and settle whether detainers, as currently used, are constitutional. For now, it's a standoff, a quiet rebellion, sheriffs choosing the law over pressure, immigrants caught in the middle, and a federal agency facing a patchwork of resistance it didn't expect. In a country that claims to respect due process, the detainer debate cuts to the core. Are people held by law or by request? Do sheriffs answer to ICE or to the Constitution? The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration News Channel, and thank you for watching, and we'll see you in the next video.